Gentleman's recognized.
This is a very important discussion today, and we have an opportunity to consider whether we're willing to respect the ideals of law and human dignity in actuality rather than just in rhetoric. This legislation goes to the core of who we are as a nation. And so I'll begin the Judiciary Committee's discussion of this matter on 2 points, simply. And the first is the point on habeas corpus. Because, you see, we have determined that detainees will not have the ability to challenge the conditions of their detention in court unless and until the administration decides to try them before a military commission. Those who are not tried will have no recourse to any independent court at any time. And so, because people have been encouraging each other to read the bill, I want to turn to page 93, line 12, where the habeas corpus matters are included. And here's what it says. No court shall hear or consider an application for a writ of habeas corpus filed by or on behalf of an alien detained by the United States who has been determined by the United States to have been properly detained as an enemy combatant. And there is where 62 law professors from dozens of universities tell us that what we are doing is changing the hallowed writ of habeas corpus so that it will not apply by law. We are by Constitution changing, we are by law changing a constitutional provision. The other important part of our discussion on the Judiciary Committee, and by the way, I hope that the ranking member of the Armed Services Committee can serve on the Judiciary Committee because he's made some excellent legal arguments today. The other point that I would bring to your attention is that the President will now, under these provisions in the bill, be allowed to interpret the Geneva Convention, especially Common Article 3, the way that he wants, and to exclude it from other review by the courts. By eliminating the judicial review of executive acts as significant as detention and domestic surveillance, this cannot be squared with the principles of transparency and the rule of law on which our constitutional democracy rests. Congress would gravely disserve our global reputation as a law-abiding country by enacting bills that seek to combat terrorism by stripping judicial review. And I refer my colleagues to page 83, section 6, relating to treaty obligations. And here it is. This is the bill. 3, interpretation by the President. As provided by the Constitution and by this section, the President has the authority for the United States to interpret the meaning and application of Geneva Conventions and to promulgate higher standards and administrative regulations for violations of treaty obligations which are not grave breaches of the Geneva Convention. The President shall issue interpretations that will be published in the Federal Register. And so what we have done now is give to the President, and I think it's about time somewhere in the proceedings that this be made public knowledge, the President the exclusive power to interpret the Common Article 3 of the Geneva Conventions, and that it would be unreviewable. And it's upon these 2 points that I would urge that the members of the House of Representatives on this day go on record as refusing to accede to these onerous provisions of a bill that would change the course of America's historic relationships with international treaties. And I reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from Wisconsin.
Speaker, I yield myself 1 minute.